Hey everybody. Hey everybody. If you can put a one in the chat if you can hear me, if I'm making a joyful noise in your ears today. We're coming live. They cut my back thing up because y'all be hearing my YouTube. We got some filings today out of Arizona that Lori Vallow made today, Lori Daybell. And so we were trying to get in touch with Gresha. She said last night on her live that her phone was being worked on, so we thought we would go live with it and hope she joins us because we got these filings today and we thought they were so shocking that we needed to go over them with everybody. And so I'm gonna reach over him if Trace or Beach Bomb or well or Little Brands or any of the mods would like to come up here with me and help me with this, I'll be really glad for you to, because I'm really new about what the filings were about. But as best I could understand, uh, Miss Miss Lori Hussey Daybell thinks that she hadn't been done right, and so they ought to just take it off. No, Natalie, we don't. I don't have Jason's number, and if you might want to have your we have somebody that lives in Arizona who got a scoop of this, and I think that the True Crime Squad may have talked about this tonight too, that Lori had put out some new filings, and for whatever reason they're not on Twitter with Justin Lum yet, or we haven't heard from Nate Eaton. So we thought we would just get out there in front of it and be the breaking news. So let me see here. I've got text going. Okay. I don't think she can see me. Who says that? Okay, so there were this is a pleading template, so I'm going to bring up, let's see if I can do that, if I can present it. Share screen. Can y'all see that? I guess you can see that. Let's make it bigger. So these are the many. This one right now that I've got up is Lori's wanting to ask for a motion to appear in civilian clothes, and so that was covered this morning, I think, on Joe Schmoe's. And I wish if Joe Schmoe is in earshot of me, I would love it if he would come up and go over this with me, and you can send it to me. Okay, that's a good idea. So she wants to wear civilian clothing. She had filed a motion about this earlier. Let me see if I can, there's a way I can make that bigger for y'all. And the Sheriff Sheridan did not object to the defendant wearing civilian clothes during jury selection and trial. But as court had previously ordered, he had, however, continued to object to wearing civilian clothing for all these hearings outside jury selection and trial. Sheriff Sheridan requests that should the court require additional information or response, direct it to him, and he would provide a response. So that was one of them. This is the other one. I may not be getting these in the right. I said this is the same thing written out. This was her request. The defendant, Lori Daybell, requests that the court and state MCSO allow the defendant to wear civilian clothing during all court proceedings. And she's got her amendments there she's asking for. So she was asking for that, but he was saying that she couldn't wear it and these little things up till that. Okay. Did I change it to the right one? Whoa. Okay. So Lori filed this one, and the person filing is Lori Daybell. I'm not going to read the book and number or the address and all that. But it's a motion to exclude state witnesses. And here it says, explain what you want the court order. The judge may grant or deny and change your request or motion. The ruling will be issued by minute entry. The defendant, Lori Daybell, requests that the state be ordered to exclude the following witnesses: Nancy Jo Hancock, Christina Atwood, and Kay Woodcock. Facts: the state witnesses listed above are not for factual testimony. They only have to offer speculation and hearsay. Federal rule something need for personal knowledge of the witness may testify on the matter only. So she don't want Kay in there. If evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter, this rule would prevent testimony to the subject of hearsay because there was no personal knowledge of the alleged witnesses, were not in communication, and had no knowledge prior to the alleged crime. Their presence was not in the location or proximity of victims or the defendant. And 52 USCA, some numbers there. If a witness alleged interpretation, contribution in name of another is prohibited. No person shall make a contribution in the other person or knowingly permit the name to be used in an effort for such a contribution. Number 3, the United States versus Whitmore. Some numbers, I'm not going to read all that. Above is a legal conclusion and testimony unlikely to assist because, among other things, it has nothing to do with the defendant's actual case. And then one from Rhode Island that says impeachment testimony demonstrates untruths in statements, especially used in prior trial, thus proves guilt by implication, and therefore such statements are incriminating in any meaningful sense of the word. Confrontational clause, Brady and something, right to due process, right to a fair trial, 7. Let's see, let me go back up here. Hey, Trace, can you send the link that I sent you to Joe? I didn't have time to do much changing of the pictures. They're like sending me all kinds of requests. Nope, I can't do it now. It's up there. But so if you want to send that link to Joe to come up, and I'm just going to be kind of reading these until he does. But the scoop of it is she's lost her mind here today and decided she's going to get some stuff thrown out, didn't she? Okay. The state witness above are meant to deprive the defendant the right to due process and the right to a fair trial. These witnesses will not be testifying to facts, but opinions, speculation, and hearsay, creating prejudice and bias for the defendant in front of the jury. In conclusion, the defendant requests that the above listed witnesses are excluded from testifying at the trial, since it was discovered in their pretrial interviews that these witnesses have been communicating with each other regarding the defendant. Well, she thinks that we all would not be talking about it for the past 5 years. In these cases, none of these communications between these witnesses have been turned over to the defense from the state. It was discovered by the defense in the pretrial interviews that such information that these witnesses gave in their police interviews was gained from speaking to Kay Woodcock long before they had interviewed by the police. All of these above mentioned state witnesses should be excluded from testifying at trial. Well, she is one demanding somebody. Lord have mercy. Okay. I think I got that one. Have I read this one? Okay, there's some more too. Let's see. Y'all hang on a minute and let me see if I can you hold on, y'all. Trace, can you screenshot the other 2 pages for Brandy? What in the world? Hang on, y'all. we are just mumbling through this, but we wanted to give this information out. Hold on, y'all. Let me look. I've got I should have like marked these as I opened them up. Respondent to defendant's motions. Oh, yeah. Y'all hang on just a minute. So we already did that one. Get back up here. What am I even showing y'all? Look at all this stuff that we've been looking at. Y'all hang on just a minute. Let me get opened up this. So Joe, did they send you a link to come up? I could put it in the chat and then hope that a bunch of people don't try to come up. Since Joe Schmoe, I'm going to put you a link in the chat. And then I'm going to proceed to look at these. So I can open it up like that and look at this suspended request to have her restraints. Okay, here's one. Okay, let me. Okay. So in this one, Lori, let's see, can y'all see it? Yes. Lori, it says this is by Lori Daybell, and this is a motion to have her restraints removed during the trial. The defendant, Lori Daybell, requests that the court and the state and that's Maricopa County, to allow the defendant to have no restraints and handcuffs and shackles while in the courtroom during all the proceedings, jury selection, and all the trial proceedings. This request is made pursuant to the 5th, 6th, and 8th, 14th Amendment of the United States Constitution, Brady versus Maryland, something numbers, and some more cases. Okay, so let's see. Self-representation, pro se status. It has been extremely difficult for the defendant to manage files, take copious notes in all trials and hearings with handcuffs. It would be impossible to represent oneself during trial under these conditions, and the defendant's appearance in restraints and handcuffs and shackles violates her due process rights. It impedes her ability to perform writing tasks. In her defense, if the defense is going to properly allow the defendant to defend herself, she must not appear separate or different from the state's representative to be able to stand, walk, and move about the courtroom as other attorneys. It's imperative to have a fair trial. If any imposed restraints cause this defendant to appear to the jury different from the state's representative, it would violate the defendant's due process rights and the right to any fair trial. This defendant's documented behavior for the last 5 years while in custody warrants no restraints necessary during the trial at all. This defendant has been through a long trial without any misbehavior at all. This defendant has only displayed stellar behavior all of the time that she has been in custody, incarcerated over these years. Hang on just a minute, y'all. All right. Joe Schmoe is here, and I'm going to invite him right on up. Hey, Joe.
Hey there. How are you doing?
I'm doing fine. I just kind of jumped in the deep end on this because I did not watch it this morning, and I was busy with some errands for my mom and my neighbor. And then they were like, oh my gosh, the woods is on fire. And so
oh, dang. You got to go take care of that, right?
so I was like, so what's going on? You give us a higher level review of what we're talking about. I'm gonna pull this down.
No, pull it back up, honestly, because
okay.
Why in the world is she submitting handwritten motions when she has a paralegal and she's also filing like typewritten motions? What's going on there?
Well, I would think that she's impatient and they ain't getting it done fast enough to suit Miss Tootie.
I get that. I totally get that. She's like, paralegal, Miss Paralegal, I need like 7 documents today. And Miss Paralegal's like, I can give you 1 or 2. Yeah. The restraints and the clothing thing, that's not, to me, that's not out of the ordinary. Like Sarah Boone, Brian Koberger, they all have certain things that the sheriff's office does with them, but they get to appear in civilian clothes. So I don't begrudge her that right to appear in civilian clothes for the trial.
Right.
They all have rights, but she's asking also for her restraints and the sheriff's office. Have you got to the sheriff's office response to her request yet?
I have not.
All right, let's do it. Let's dive
do it.
into it.
Okay, so let me figure out which one is the let's see, response to the, let's see, to restraints. Is that the one we want to open?
Yep.
Okay. Well, where did it go? Okay. I can't tell whether let's see. Let me make sure if I've got the right one up there. It's hard to tell.
Non-party Maricopa County Sheriff Office's response to defendant's motion for defendant to have removed restraints in trial. That's the one. You got it.
Okay. Then I'm going to move it up and I'm going to let you talk about it because you were probably like I said, I'm the first time seeing this, so you'll be way more familiar with what's going on here.
Right. Although a defendant has the right to be free from restraints in the courtroom, concerns for courtroom security and safety and security may make the use of restraints appropriate. So this is the sheriff citing case law, that is Arizona case law. He cites two cases. Courts evaluate the need for restraints on a case-by-case basis, reflecting the particular concerns related to the defendant, including special security needs or the risk of escape. So, Trace, you and I've been there. You and I know that if she breaks out of that courtroom, she's not going anywhere. Like, she may make it to the elevator, she may make it to the bathroom, she may make it to the water fountain, but she's not breaking out of the courtroom building. Like Maricopa Superior Court in its entirety is a big complex. It's huge. But because Arizona law, so we're looking down at line 6, including State versus Gomez.
Did I move? Okay. No.
You're right. Does not delineate the factors a trial court may consider to evaluate particular concerns justifying restraints at trial. So Sheriff Skinner, that's the Maricopa County Sheriff, and he's the one that's in charge of her security. He's citing 2 non-binding out-of-jurisdiction cases, which is perfectly acceptable. They do it all the time, permitting a party to cite it. We don't need to do that. Line 10, line 11. It's all legal mumbo jumbo. Minnesota versus Chambers. In determining whether restraint is justified, we look to the following factors: the seriousness of the charge. This is a pretty serious charge, right? Conspiracy to commit murder, conspiracy to commit felony 1 murder. That's a pretty serious charge. Okay. The defendant's temperament and character. Let's not get into that. we could go for hours on her temperament and character. But number 3, the defendant's age and physical attributes. So she could probably run, medium fast. Could she outrun a deputy? Probably not. The defendant's past record. All right, she has a past criminal record, and we heard in the last hearing that the jury is going to hear about her convictions, but we don't know what they're going to hear about the convictions. They're going to hear that she's a convict, but the judge said he may sanitize, he used the word sanitize the jury so they don't know that she was convicted of murder. But honestly, do you really think that anybody on that jury doesn't know about that? Number 5, the defendant's prior escapes or attempted escapes. She hasn't.
Well, well, she
Oh
hasn't.
yeah, well
But
they went to Hawaii, right? Yeah.
exactly.
She tried to flee. She and Chad tried to flee to Hawaii, and Nate Eaton. And I know some people have mixed feelings about Nate Eaton, but I really am a fan of Nate Eaton. He tracked her down in Hawaii. So she tried to sit there by the pool, and she got served by the pool.
Yep.
Number 6, threats made by the defendant to cause a disturbance. Number 7, the size and mood of the audience. Yeah, right? Is that not something? The size and mood of the audience? Should we like put something in chat like to gauge the size and the mood of the audience? Like for real though, for real. This is a real thing. Like this is a legal decision.
See that. I can see that. I mean, if you had someone who the community supported a lot, even though they were a real scandal, they might fill up the courtroom, and it might get a little scary that they might, whoop somebody and make off with the prisoner,
Oh, that's a good point.
I mean, I can see how that would be, or two, if a lot of people there maybe wanted to kill them. They,
right.
They would,
exactly. One way or the other. Do we have a lynch mob? Do we have a freedom mob? Like a mob, like takes me back to the 1800s, but still, I mean, it's a thing. Like if you want to talk about Mormonism, I mean, Joseph Smith was supposedly killed by a lynch mob in Carthage, Illinois.
Exactly. Yeah, but I mean, a real mad group of people without a lot of guidance can really do some damage.
Yeah, but they're not going to at the Maricopa Superior Court. I guarantee you. I've been there a handful of times, and there's no mob going to do anything at the Maricopa Superior Court.
I was always surprised and, very glad to see whenever they were having court, the way the sheriff's department, I guess, I don't know what you call the people who work in the courtroom staff, they look like they're waiting on trouble every second of the day. I don't really think you'll sneak much past them. And
yeah, I don't know. They let Trace on the case. They let her in early. Like the last time we went, she got to go sit in early. So I think their guard may be down a little bit because she's a troublemaker.
They were slipping that day.
Oh my gosh! All right.
I'm never gonna let you get done. I'll move it up a little. Okay, there we go.
Number 7, the size and the mood of the audience. All right, we got that. And that one is a curious one to me. Like they can seriously consider that and whether or not they're going to put her in handcuffs and leg irons, depending on the size and the mood of the audience. That boggles my mind. But anyway, number 8, the nature and security of the courtroom. And Judge Boreski's courtroom is a tiny courtroom, but we know we're moving to Judge Kemp's courtroom. So it's going to be a bigger courtroom. So they may actually bring in more security for that. Maybe, probably. And number 9, any less restrictive available alternatives. The need for restraints may be inferred from attributes of the defendant and his or her prior conduct. So that's the case that the sheriff cites in objecting to her motion to not be in restraints or to be in less restraints. And he has another one here too. State versus Powell. This is in Kansas from 2002. Each case must turn on its individual facts. We hesitate to set forth any list of factors required to be considered, but the background of the defendant, the nature of the charges, evidence of dangerous incidents. We have some evidence of dangerous incidents with this lady.
Yep.
Yeah, we do. Testimony about the restraint sought to be used, prior conduct of the defendant, the objection to use of the restraint, and or the election by the defendant whether to testify. So that's a big thing in this. Number two, the election of the defendant to testify. We don't know, and we probably won't know until the last minute if she plans to testify on her own behalf. We did hear at the hearing that if she does testify on her behalf, she does not get a narrative testimony. So we saw in the Sarah Boone case in Florida, the suitcase boyfriend case, that she got to do a narrative testimony. And in Las Vegas, Robert Tellis, who was the real estate agent that was convicted of unaliving a newspaper reporter that wrote negative articles about him, he got to testify in a narrative. And Judge Boreski says, nope, you're not doing that here, girl. You're going to have to submit questions ahead of time, and one of your advisory councils or your paralegal or your investigator, one of those people are going to have to ask you those questions that you submitted ahead of time. You're not just going to be able to get up on the stand and just say what you want to say. And to me, that's huge.
Well, it is huge, but the fact that she's writing the questions and the answers is kind of, it's real contrived. And also, but the thing about it is even in that situation, like in the situation when she was being interviewed, she is like a snake to tie down. You know what I'm saying? She doesn't. She's going to wiggle around the whole time after they ask her question that she already knows what she's going to say to. You know what I'm saying? It's kind of weird, but we'll just have to see.
Yeah, but those questions will have to be approved by the court ahead of time. So
right.
Yeah,
it's way better. It's way better than us getting a scriptural lecture. I'll give you that.
Yeah, and much better than her quote unquote mitigating statements that she made in Idaho.
Oh my gosh!
Where she said Jesus Christ knows that nobody was murdered here. Like I don't think we'll get to hear that, and thank God we won't get to hear that, because it's just.
Okay, I'm gonna roll up a little bit here.
All right. There's a lot to go through. Like, she filed pages and pages of documents, and
the
state filed. No, you're fine. No, that's how we sort through it, because this is a tough case, people. Like, she's a tough defendant. Like, she's a tough nut to crack, but we cracked that nut by figuring it out between ourselves. And it's already been cracked in Idaho. Like, she's serving 3 life sentences in Idaho already. So that's how they cracked it. And I appreciate everybody that subs up to my channel. I appreciate that. I'm just a little.
Let me look up. I don't even. How many people are in here, y'all? This is Joe Schmoe that's speaking with us now. Y'all might not even know who I am. I am Donna Donald, and I'm the moderator, and I go by also Sis. Sis, you should have been a detective. That my brother told me that one day, and he was teasing me. He was like, Sis, you should have been a detective. And I thought, well, that sounds good. Anyway, so we are taking over for Cresha tonight because Cresha's got a communication problems at her house right now. Her phone is broken. It's going to be a day or two before she gets another one. And so Beach Bum and Trace were listening to Joe, and he had this great scoop, and we said we need to get it on out there. And Beach Bum, is this Joe's link you've put in the chat?
She did.
I guess
she did. Trace put my link in the chat.
Y'all, everybody, please sub up to him and listen. He puts out great videos every day. He puts them out a couple of different times a day. So If you miss one, you can get the other one. You can watch them on the rewatch. But see, you miss one day and you miss something important. See what happens?
Yeah,
I bet I
we
pay
missed all
attention
these
in.
docs.
Yeah, and I bet I pay attention in the morning, people.
We probably
All
won't.
right.
We probably won't go tomorrow morning. I try and do like every other day, like Monday,
Okay.
Wednesday, Friday type of thing.
Okay. Okay. Well, I sure am glad you have been doing this, and you're just such a blessing to our whole team. I just want you to know that, and y'all sub up to him. He should be having thousands of subs now. Let's go do it.
Right. So I am not a conceited or egotistical person, but damn, I should have like 50,000 subs.
Exactly.
Just because I'm a good investigative reporter and I care about this case, and I'm going to be at trial every single day for this case, and I'm going to look Lori in the eyes, and she's going to know when she looks in my eyes that she shouldn't have looked in my eyes.
We're going to have the good this time, y'all.
Yep.
We're going to have it. Okay. All right. Well, let me get this back up here and you can
all right,
continue.
where were we at? All right, line let's go to line 22, the above page. The nature of the charges, evidence of dangerous incidents, testimony about the restraints sought to be used, prior conduct of the defendant. Okay, that's where we stopped, line 23. The objection to use of the restraint and or the election by the defendant whether to testify, the physical facts of the individuals in the courtroom, the presence or absence of victims, family, or spectators. That's a big one to me, actually. But she's not a threat to that. Like if family shows up, if family of victims show up, I think that's going to be more to her detriment, right? Like she's not going to appreciate that. Anyway, other factors that will vary from case to case must be considered by the trial court. Typically, inmates attending trial wear leg braces and a remotely activated custody control belt, which allows detention officers to deliver an electric shock via remote control. I think I asked earlier in chat, who wants access to that remote control?
Well, I like that. I'm going to tell you something. Anybody that would do that crap to their kids is liable to haul off and jump on somebody and bite them in court. I'm just saying. Yeah, I'm just saying. You just don't know what these people are. We certainly did not think they were capable of the stuff they did.
All right, we're on page 3 now, so you can scroll up. Okay. Both devices are worn under the clothing and cannot be seen by the jury, so they're not prejudicial. If the jury sees you in handcuffs or in some type of restraint, that can prejudice the jury towards you. Handcuffs, leg chains, and inmate uniforms are not typically worn during trial, and that is true for the defendant here. In the defendant's case, line 4, Maricopa County Sheriff's Office has reviewed the defendant's request and recognizes that the defendant may need to move about in the courtroom as she is appearing pro se. So a lot of states call that pro se, whatever it is. That means she's representing herself. See Exhibit 1, Maricopa County Security Recommendations. However, pursuant to the Maricopa County Sheriff's Office policies and procedures, and their duty to maintain control and custody of inmates and ensure the safety and security of the courtroom, defendant cannot go unrestrained. As such, the Maricopa County Sheriff's Office. So this is the sheriff's filing. This hasn't been ruled on by the judge yet that I know of. But this is the sheriff's office filing. The sheriff is saying she has to go unrestrained, and the sheriff's saying, no, not going to happen. And I'm pretty sure the judge is going to rule in his favor. Anyway, line 8 to 9, the use of the RACC vest, and in addition to detention officers in the courtroom during the defendant's trial. The RACC belt is designed to temporarily stun an attacking detainee, thus buying time for courtroom security officers to react. The belt sits comfortably on the defendant. That's an objective term. If I'm wearing that belt, it may not be so comfortable. If you activate the electric shock, it's going to be a lot less comfortable. But with straps adjustable to a particular defendant's body type, the belt is not visible to the jury. Further, the belt works on a one remote, one sensor system, ensuring the activation of other remotes will not trigger the vest. So there's a particular remote control for the vest that she's going to be wearing in trial. These two security devices permit the Maricopa County Sheriff's Office to restrain defendants in the courtroom without any restraints in the courtroom. The Maricopa County Sheriff's Office would have to recommend an unarmed detention officer and an armed sheriff's deputy to be in the courtroom.
Wow.
So as such, to date, I have not seen any armed sheriff's deputies in the courtroom. I know when Lori is getting ready to come out and take her seat at the defendant's table, because a deputy comes out wearing blue nitrile gloves. Call him Blue Glove Bailiff. So he puts on blue nitrile gloves. He brings her out. She sits down, and then he takes the gloves off. But if she didn't have a belt, then the sheriff says, we're going to have another armed deputy in there along with Blue Glove Bailiff.
I'm just looking.
Zap, zap. MM says zap, zap. All right. Should we start a GoFundMe for who wants to take control of that remote control zap vest? Oh my gosh.
Okay. So, let's see, this was the response to, I read the one about, this is about her wearing civilian clothes. Is that very interesting, or just about what you would think?
No, we can. No, I like it. I wouldn't mind reading that, because that was very similar to the Sarah Boone case, and also Brian Koberger. Like, a lot of people want to say, oh, there's no crossover between these cases. There's no crossover between Delphi and Idaho 4 and Sarah Boone and Lori Vallow Daybell. There are legal crossovers, and one of those is, what do you get to wear to your trial and your hearings before the trial and jury selection? And that's what this one's about. So she filed a handwritten motion to wear civilian clothing, and this is what the Sheriff Jerry Sheridan had to reply, how he replied. Maricopa County Sheriff Jerry Sheridan hereby files his objection to the defendant's motion to appear in civilian clothing at trial, quote unquote, motion, because this issue has been raised and decided. Defendant's motion should be denied.
What?
Yeah. I think we might be seeing contradictory statements in this filing, because I remember reading it this morning and thinking that she was going to be allowed to wear civilian clothing at her trial. Okay. I think once we boil down, we'll figure out that we have 3 different time periods that we need to think about how she's going to be dressed. So we have pretrial hearings. We have pretrial hearings, which we've had several of those. And then we have jury selection, which begins on March 31st and through that first week of April. And then we will have the trial. So I think, if I remember right, this motion is more about pretrial stuff than trial stuff. But let's find out. Defendant, line 23, defendant previously filed a motion to wear civilian clothing on June 26th. 2024. The sheriff's office filed an objection on this motion on July 2nd. The court issued an order stating it is ordered denying the motion for future hearings except for jury selection and trial. Okay, so this is like delineating pretrial hearings, jury selection, and trial. All right, line 26. The Sheriff Sheridan does not object to the defendant wearing civilian clothes during jury selection and trial, as the court has previously ordered. He, however, continues to object to the wearing of civilian clothing. Can you please? There we go. Civilian clothing for all the hearings after or before jury selection and trial. Sheriff Sheridan requests that should the court require additional information or response, that direct him to provide such a response. So yeah, that's it. They're just differentiating between pretrial hearings, jury selection, and the trial. So the sheriff does not object to her wearing civilian clothing during jury selection and trial. So she will show up. I wonder if she will have a court-appointed specialist to pick out her clothes, like Sarah Boone did in Florida. That will be an interesting thing to see. Like, will she fire will she fire that person that is supposed to find her clothes that she thinks are appropriate to wear to trial if she doesn't find her clothes that she feels are appropriate for trial? I just can't take it. I just can't tolerate this girl. We need somebody else.
It's something going on. So, what is it? Oh, is there an answer to this one yet about the
oh my gosh, no, the court has not. I don't even think that there's a reply yet from the state on this one.
So do you know? Go ahead.
This is a big one. This is a big one, and I need you to guide me along through this one, because this isn't like a legal matter. This is like a personal matter. Like, she is calling out people personally. So you need to guide me through this.
So we got to figure out who. Of course, we know who Kay is, and Christina Atwood was one of those girls that did either the one that was down in Hawaii or one of those prayer girls that did the prayer circles and stuff. But Nancy Jo Hancock, let me think about that a minute. Does anybody in the chat know? Do you know who Nancy Jo Hancock is?
Let's talk about Kay, though, because we know who Kay is. Why does she want to exclude Kay from being a trial witness for the state? I don't get it. She explains, she has an argument that is down below the names.
Right. Okay.
But yeah. So if you scroll down, you'll see what her argument is, but it just does not make sense to me. A witness may testify to a matter only if evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. And this is underlined by Lori. Lori is underlining the witness has personal knowledge of the matter. So what did Kay have personal knowledge of or not have personal knowledge of that she's going to be called to testify to by the state? This rule would prevent testimony to the subject of hearsay because there was no personal knowledge. So Kay didn't have personal knowledge of conspiracy between Alex and Lori, because that's what she's on trial for in this case. This is the 2021 case. This is conspiracy to commit murder of Charles. And we know he was unalived by Alex. So does Kay not have personal knowledge of that, or does she have personal knowledge of that? And I don't know. I honestly don't know. Lori says the alleged witnesses were not in communication and had no knowledge prior to the alleged crime.
Well,
their presence was not in location or proximity of victims or the defendant.
I know that Kay overheard Lori talking real mean to Charles one day because he did not know. I mean, she didn't know that Kay was there. They were in Texas, and I think that I'm not sure about this, but I think Melanie Gibb may have been there too. But at any rate, Kay overheard some stuff. So I don't know whether that's, I mean, she overheard the two of them, what the conversation was.
Right. So conspiracy is the charge, and conspiracy means two people are talking about committing a crime together. So if you overhear that conversation or parts of a conversation, it's
I'm just
interesting.
saying, I don't know what she said to him. I don't know what was said.
Right.
But it may have been enough of a threat or some part of this whole rigmarole. But for a fact, and I don't even know, is it hearsay? Like, this is my thing. Like, for instance, Charles is on video stating all the same things that she actually done.
Right. Interviewed on police body worn cams
Right. But I mean, there's so many things like that. It's like, Charles told his lawyer things that were legally put down and recorded at a damn lawyer's office. Is that still considered hearsay because he was afraid she was going to kill him? You know what I'm saying?
Right. He predicted his own demise. He did. And he, from what I know, and I'm on the outside looking in, so y'all can correct me if I'm wrong, but he seemed like a genuinely good dude that took JJ and Tylee into their house, and Ryan, and Colby, damn it, and tried to be a good stepdad to them. And then when she was like melting down, when she got into this Chad crazy crap, he tried to get her help. He told the police she needs to get help. He told them that, and it didn't happen. So that's just my opinion. I am way on the outside looking in, and I don't know all of the details or even 50% of the details or the facts of this case. But Charles Vallow seemed like a good dude to me. He did.
I think he was a good person. Okay, where were we here?
I don't know. Kresh is finally logging in here. She's in chat. Kresh, what up, girl?
Y'all stole my channel.
Right? We're messing up your channel. You're gonna have like 400 people like drop off as subs after this just because of me.
We was breaking news for you, baby. Okay. All right. Okay. Well, let's keep it going then.
All right. Let's keep it going. Let's keep reading these handwritten submittals by Lori. Like, what the heck? If a witness alleged interpretation, contribution in name of another is okay. What the heck? Like, her legal writings, y'all are going to start having me perpetuate what bugs me on my channel is her syntax and her grammar are so screwed up. Like, she can't even put together a sentence in some of these paragraphs, and it bugs the crap out of me because only because she wants to be the smartest person in the room. Like, if this was Sarah Boone like writing this, I'd be like, hey, all right, whatever, make your grammatical and your syntax errors. It doesn't bother me. But this is Lori Vallow Daybell, and she can't put together 3 paragraphs in a row without a grammar or syntax error. For real. Like, I can point them out to you one by one. But anyway, all right, we're in paragraph 2. If a witness alleged interpretation, contribution in the name of another is prohibited, no person shall make a contribution in the other person or knowingly permit name to be used to effect such a contribution. See, that just makes no sense. That's just cray. All right, paragraph 3. Excludable 52 USCA 30122 above as a legal conclusion. Testimony is unlikely to assist because, among other things, it has nothing to do with defendant's actual case. I would word it differently, like underlying facts, like foundational facts of the case, but all right. She's citing case law. That's fine. Rhode Island versus NS 466 US 291 100 S Court 1682 64 LED ZD 297 1980. She's doing her research. Impeachment testimony demonstrates untruths in statements, especially used in prior trial. Oh, she's mentioning a prior trial. So she doesn't want her prior trial and conviction mentioned by the state, but she's bringing up her prior trial right now. This is like the third from the bottom line. This proves guilt by implication, therefore such statements are incriminating in any meaningful sense of the word. USCA Constitutional Amendment 514. So that's Fifth Amendment and 14th Amendment is what she's citing. All right, paragraph 5. Wow, man, she's long-winded. Confrontation clause, paragraph 6, Brady Giglio, paragraph 7, 17 ARS Rules of Evidentiary Rules 806, attending and supporting the declarant's credibility, confrontation clause. Like, she's not making arguments. She's just like stating cases. So does she want another hearing before trial? I think we may get another hearing before trial because of these filings. Paragraph 8, declarant not available. Paragraph 9, exception to the rule against hearsay. Paragraph 10, testimony of a witness is excluded as not admissible. And then her summary of all of this: the state's witnesses above are meant to deprive the defendant of, she should say of in here, the right to due process and right to a fair trial. These witnesses will not be testifying to facts, but opinion, speculation, and hearsay, creating prejudice and bias for the defendant. No, it's against the defendant, girl. Prejudice and bias is against the defendant in front of the jury. She can't even get one freaking paragraph right. All right. Can you scroll down, please, for the last? You're all right. You're all right. She has one more paragraph, and she just like, she wears us all out. Oh, wait, she has more than one paragraph. Holy crap. In conclusion, the defendant requests the above listed witnesses are excluded, no, should be excluded, or from testifying at trial, since it was discovered in their pretrial interviews that these witnesses have been communicating with each other regarding the defendant. So if somebody is like law knowledgeable in chat, let me know. Can you let me know if witnesses in a trial shouldn't be talking to each other about that trial? I don't know if that's not allowed or if it is allowed, honestly, one way or the other. If it's not allowed, they shouldn't be, but she's saying it's not. All right. Last page, I hope. Good Lord, Lori, I hope this is the last page. In these cases, none of these communications between the witnesses have been turned over to the defense from the state. Well, the state wasn't interviewing them. If they were just like talking amongst themselves, the state has no responsibility to record and provide that in discovery. It was discovered by the defense in these pre-trial interviews that much of the information that these witnesses gave in their police interviews was gained from speeding speaking. From speaking to Kay Woodcock long before they were interviewed by the police. Oh, that's interesting. She's coming at Kay. She is coming after Kay. All three of the above mentioned state witnesses should be excluded from testifying at trial. All right. Wow.
Okay. That's all that in it. Okay. Was that the last one of the?
I don't know. You're in charge of the doc drop.
I don't know whether I got. Let's see if this is the same thing. I may have the court. Okay, now we already did that about
La Mesa Filipino Food Club. Good to see you in chat. It's always good to see you.
Okay, that was about the close.
Yeah, the close and the witnesses and the restraints. Like she had like 4 of them that dropped in the last couple of days. And then she had one that dropped tonight. Did you get the one? Did Trace send you the one that dropped like yesterday?
I don't know. What was it about? That would be.
Hold on, I gotta pull it up.
Okay.
Proper notion, proper. So, oh, it's the jury questionnaire. Have you seen the one about the jury questionnaire?
I have not.
So she dropped one that's dated the 20th.
And there's
So
also one about 404s too.
What? I haven't seen that one, or have I?
Well,
I can't keep track. It kind of feels like she's just like flooding the court with documents, right? She's just like throwing stuff out there.
Motion to disclose the evidence. Is this the old one or a?
Hold on. Let me get in StreamYard and look at it.
Request. All of the four.
No, that's new. That's relatively new. So it shows March 14th, which was 4 days before the hearing. But if you go to the top of that, I think it didn't actually show up in the court filings until the 18th.
Yeah,
yep.
That's right.
Yep. That's a newer one. She's pulling out all the amendments of the Constitution.
Brutus, hush. All right, I'm just checking all these things I downloaded.
Yep. No, there were 7 of them. I think 4 were by her, and I think 3 were by the state. And I check like 3 times a day, and I swear they didn't show up until this morning or yesterday morning. And then there was a new one that showed up that has to do with with the jury questionnaire.
I don't think I have that one about the jury.
I think I sent that to Trace. I think.
Okay. So that must. I wonder if she sent it.
But we could look at this one. I mean, this one is interesting also. It is. The request is pursuant to the 5th, 6th, 8th, and 14th Amendments of the United States Constitution. She's pulling out her constitutional rights. Brady versus Maryland. So she's going Brady and Giglio with her rights. So let's see if she actually makes an argument or if she just cites like more court stuff down below. But we got a page 1 of 3. So we got to see 2 of 3 and 3 of 3. 2 of 3 is just signatures. 3 of 3. Okay.
So was there one about where she's trying to get the whole thing like shelved over them not reading her emails or something. I forgot now.
Oh, yeah, that's one that I downloaded like a week or so ago.
Okay.
Yeah, like her, like.
Well, we see that didn't work. Okay, let me go back to this pile of stuff here that I downloaded that I need to, I guess, color code them. Okay, this one was about the motion for the restraints, and we already done that one. And this was the response. Let's see. Y'all just hold on and bear with me for a minute.
You're good. We got time. We got lots of time. Jury selection doesn't begin for a whole nother week. We got time.
And we did the one about the restraints, how they were going to do her about the restraints.
Yep.
We especially like the part about the shock vest. I'm sorry, Lori, if you're listening to us. Nothing personal.
I'm not sorry. I'm not sorry.
Like they're laughing at me. Okay.
Dude.
Okay.
If you want to see the latest filing that I downloaded this afternoon.
Yes.
Boom. I put it up in StreamYard.
Okay. I've got so many windows open and
right. My
else.
brain has like 53 windows open, tabs open, like all day, every day.
Okay, let's remove this one. Let's add this one.
There we go.
And all right.
So this was filed the 20th. So what are we today? Is the 24th. So that would have been last Thursday, 2 days after her hearing, her last pretrial status hearing. Notice of objection to jury questionnaire. So she got a copy of the jury questionnaire that the judge and the state preliminarily published. I gotta dance around these tricky words. What's interesting is if you look right here, she's only citing the 2021 case. In almost all of her filings, she cites both the 2021 case, which is conspiracy to commit murder of Charles Vallow, and the 2022 case, which is to conspiracy to commit murder of Brandon Boudreaux. She's only citing the one in this one. So that's interesting. She's probably got the help of her paralegal in this. Anyway, notice of objection to jury questionnaire. The Honorable Judge Justin Bareski. And by the way, I love Judge Bareski. Like, I think he is on it. And I'm glad that he's in it for the second trial too. Totally glad that he's sticking around for the second trial. As long as they wrap it up by July 4th. But if she wants a different judge, like, she can stretch it out. Like, she can stretch out the first trial like twice as long as it should take. And he won't be around for the second one because he has to move on. All right. Anyway. The defendant, Lori Daybell, gives this court notice of her objection. This is brand new breaking news. Like, I just downloaded this afternoon. Even though it says it was filed on the 20th, it was not, because I checked the docket 2, 3, 4, 5, 6 times a day. This is brand new documents, hot off the press. The defendant gives this court notice of her objection to the most recent version of the jury questionnaire that circulated between Judge Bareski's division and counsel on March 20th, 2025. So her hearing was on the 18th, Tuesday morning the 18th, so that would have been on Thursday the 20th. More specifically, the defendant objects to question number 12 of the jury questionnaire and suggests that the current language be replaced with the following. So we can't see that jury questionnaire. That was not uploaded to the docket. We don't know what that says. We only know parts of what it says based on this filing right here. Line 19, the state alleges on July 11th, 2019, this is what Lori wants it to say. And I know, Kresha, I know this date and this time resonate with you. I know, because this started the start of your difficult research, Kresha. And this is mentioned in this filing. Line 19, the state alleges on July 11th, 2019 at approximately 7:37 a.m. Charles Vallow arrived at a Chandler, Arizona residence where his wife, Lori Vallow, now Lori Daybell, and children were living. The state further alleges that Lori Vallow Daybell conspired with her brother, Alex Cox, to kill her husband, Charles Vallow. Lori Daybell denies this allegation, bold underlined. So Lori's adding that to the jury questionnaire. Line 26, the defendant would also like to bring it to the court's attention that the state's quote-unquote final trial management conference pretrial statement was filed on March 13th, 2025, was not a joint statement, and the state did not confer with Mrs. Daybell. So I know she's writing this. When she says Mrs. Daybell, she's writing it. When it says Ms. Daybell, it's her paralegal. So Lori's writing this, or any member of her defense team prior to filing this statement. The defendant requests that this court also require the state to amend the language in the final trial management conference pretrial statement that was filed on March 13th. And I think I looked at that on one of my morning shows a few days ago. Oh gosh, that was the 13th. So probably a couple weeks ago, week and a half ago. Anyway, where it states, line 7, brief statement of case to be read to jury. To reflect the defendant's objection and suggested language. The state alleges on July 11, 2019, at approximately 7:37 a.m., Charles Vallow arrived at Chandler, Arizona residence where his wife, Lori Vallow, Lori Daybell, and children were living. The state further alleges that Lori Vallow Daybell conspired with her brother, Alex Cox, to kill her husband, Charles Vallow. Lori Daybell denies this allegation. So she's just wanting to put into the jury instructions that she's denying the allegations. That's actually not unreasonable for a defendant. That's not unreasonable. If I were a murdering wife with a trail of dead bodies behind me, I'd probably deny it too.
Hush, Brutus. Do you hear him?
I do. Yep. That's all right.
I thought I had it muted, and clearly that mute button on my mic does not work. I don't know what he's talking about.
Mojo Ryzen, thank you for subbing. I appreciate that. Appreciate that very much.
Yes, y'all be sure and go and sub to Joe. And Kresha, were you gonna come up or not come up? Or you don't have to.
Maybe we're doing a good enough job. Maybe she can just like sit back and cruise, put it on cruise control. Maybe. This is going to be tough. This is going to be tough. So then the state filed a response to that. So let's see if I can pull that up.
Okay. I was looking to see if she had answered in the
chat. Yesterday, Sunday. So the state has filed multiple motions on Sundays. So they're working like around the clock. You know, most government workers just like take weekends off and they don't even like check into their email over the weekend. But Rachel Mitchell, Maricopa County Attorney. Let's see.
Oh, you need me to add that?
Yep, there we go. Perfect. Rachel Mitchell, Maricopa County Attorney. She's not the gal that shows up in court. That's another gal, and I can't remember her name off the top of my head. In the Superior Court of the State of Arizona and for the County of Maricopa, state's response to defendant's motion to dismiss for prosecutorial misconduct. Oh, this isn't even in response to that one that we just went over. This is the one about prosecutorial misconduct. This is a big one also, because she's alleging prosecutorial misconduct. And I went over it on my live this morning, and oh man, I can't go back over all those. I can't, but it's a jumbled mess. But everything she's involved in is a jumbled mess, right? The state of Arizona, through undersigned counsel, so this is a state filing, request this court deny. So the state's requesting a denial. The judge hasn't ruled on it yet. Judge hasn't ruled on restraints in the courtroom. Judge hasn't ruled on civilian clothes in the courtroom. Judge hasn't ruled on the one that we just saw. Judge has to rule on a lot of stuff before we get to March 31st. We're only a week away, dude. You got some work to do, Mr. Boreski. All right. The state responds to each of the three allegations by noting that the facts, as alleged by the defendant, as to each issue are simply untrue. Liar, liar, pants on fire, Lori. Like, that's it. That's it. I love it. On September 6, 2024, the state became aware that the defense had made a public records request to the Gilbert Police Department. The state emailed defense counsel and asked them to request. So that's back when she had a separate defense team, right? Back in September of last year, September 2024, she had an actual defense team, a public defender's team. And she ended up getting evaluated for competency, being found competent. And in December, I think it was December 6th, if I remember right. So this would have been 3 months before that, September, October, November. Yeah, 3 months before that, she still had a public defender's team. So the state emailed her defense counsel at the time and asked them to request these items from the state. The state also requested the documents listed in the defendant's public records request from the Gilbert Police Department. So keep in mind, we have two different crimes and two different Phoenix suburb police departments involved here. So Chandler and Gilbert are different smaller cities, suburbs outside of Phoenix. One of them was where Charles Vallow was unalived, and one of them was where Brandon Boudreaux was attempted to be unalived, afterwards which Chad said he can't do anything right. In other words, Alex missed. Anyway, I've done some body cam reviews of that on my channel. Oh, Kresha, thank you for sharing my channel out there. I appreciate it so much. I'm just a little bitty baby YouTube channel, but for some reason so I'm out here staying with my son for the winter in the East Valley, and just happened to be able to go to Lori's hearings. And this case has just like grabbed me and like pulled me in. And I can't stop until we see justice for Charles and JJ and Tylee. Obviously, the Idaho case got us part of the way there, but this case will get us more of the way there. And I'm here for it. I'm here for it. All right, we're down to when the state obtained the documents that defense had requested from the Gilbert Police Department, the state disclosed them on October 1st, 2024 as bait stamped pages 100,816 to 100,934. I love it. They're citing like specific examples. We gave you this stuff. Stop saying we didn't. On September 18th, 2024, the state became aware that the defense had made a request to the crime analyst section of the Chandler Police Department. So we're switching from Gilbert Police Department to the Chandler Police Department. Remember what I just said about where Charles was unalived and where Brandon was almost unalived? Chandler versus Gilbert. The state was advised that the defense request was improper because it was made to the crime analysis section rather than going through the public records request process. No, it doesn't work that way. You can make a FOIA request, a public records request, to any department in any public agency. So I'm not, and I never will hold up for Lori, but that part doesn't make sense to me. All right. The state was advised. All right, I got to check chat. I got to stop. I got to take a breath. I got to check chat, guys. I have to, for my own mental sanity. Like, if that's a thing, is there such a thing? Yeah, it wasn't written as unalived. I say unalived on YouTube because murdered is a trigger word for YouTube. So sometimes they'll like strike you for that. But Charles was by Alex, by Lori's brother. So the differences between Chandler and Gilbert look like they're coming into play here, and that matters. It matters. All right, let's go. The defense request was improper because it was made to the crime analysis section. MB, I've got to bring humor into this. I have to. I'm glad I cracked somebody up. I usually crack myself up way more than I crack anybody else up. I do. Like, I find myself funnier than most people find me. It's just a fact of my life. And I'm going to keep cracking myself up. I am. The state was advised the Chandler Police Records Specialist Section spoke with Laura Moyes. There's a name I haven't seen before. Who sent a request for the log records for all digital devices downloaded. Oh my gosh. Okay, this is big. This is big, people, because remember at the hearing last Tuesday, remember this. Lori claimed that the state was withholding the video in the interview room. And she said, and her team said, and they whispered about it in front of the microphone, we didn't get that. We didn't get that from her former defense team. We only got a 22 terabyte hard drive from her former defense team. So this is big. This is big news. Like, for me, it is. I don't know what it is for y'all, but the state was advised the Chandler Police Records Specialists Section spoke with Laura Moyes, who sent a request for the log records for all digital devices downloaded. So remember when Lori said, I want my husband's phone? And she was talking about Charles. I want my husband's phone. How do I get my husband's phone? The state says that download occurred and was included on the 22 terabytes, 28 terabytes, whatever, 22 terabytes. State said that download's there. All right. The state was also advised that the Chandler Police Department did not know what was being requested as quote unquote log records. Chandler Police Record Specialist section advised Laura Moyes that when computer crime detectives are involved in a case, their supplemental reports contain download information on all devices that the Chandler Police Department extracts data from. I am 99% sure, Trace on the case, you got to correct me. She said his phone was at the Gilbert Police Department, did she not? So here we are getting information about the Chandler Police Department. I'm so confused. I can't keep up with it. I need help. Trace on the case, you can help me.
Okay. You want say that again? Ask the question
So
again.
I'm pretty sure at the hearing that Lori insisted that Charles's phone was being held by the Gilbert Police Department. But here we are seeing a filing about the Chandler Police Department, and I think she may be getting them mixed up because I'm freaking getting them mixed up. I can't keep track between the two. Like who has what and how did it get there and when did it get there and related to what investigation? You know what I mean?
Yes. Well, there's at one time Charles had her phone and she had to go pick it up. So it may be
Yeah,
that's
he had her purse too, right?
but I don't remember which whether it was
Chandler or Gilbert. Yeah.
I don't remember that.
And I've got videos. I've got them stacked up in playlists like from previous lives, but we don't need to get into that. But it just, I think the main point is it's confusing, and I think she may be confused. I think
Yes,
Lori may be confused about where his phone is or who has what video about what interviews.
and Travis, as Travis says, didn't she have his phone? Yes, whenever he was killed, she took the phone, and the police had to come back and get the phone later. So she had the phone long enough to look through his phone and know what the heck all was on his phone if she knew the passcode.
Well,
Sure
so somebody suggested at one point in time that maybe he was having an extramarital relationship, and I just saw that like one time in passing on one channel, and it just doesn't strike me as being true to his character.
Well, I don't think that he was, but I do know that he thought that he was getting a divorce and that he was planning on moving on and he was planning on marrying another good LDS woman. That was his plan. And the reason why I know that was his plan is because he had went on a dating site for LDS people and had met somebody that he was talking to. I don't think he was like having an affair or sleepovers with her or whatever. Kresha will know more about that, but I think that was in the Chandler and that big drop of documents we had, that there was an interview with a lady who had been on a date with him. But like I said, it was after they were already separated, and
right,
it was
he was already resigned to the fact that it was over.
Right, and it was an honorable type date. I think they went to eat and talked and stuff like that. I don't think it was a tawdry thing.
Well, if he's Ned, then I mean, Ned can do whatever he wants. Sorry, I couldn't resist.
But see, it's the weirdest thing though. But you would think after this experience that Charles had been through, that he might want to get some floozy someplace or some this, that, or the other thing. But he didn't. He was thinking, I want to get a good Jesus loving woman. Even, you know what I'm saying? He had that on his mind, even if that close to his death. He was that sure that this was the way to have, this was the way to have a good life.
Right. So answer me this. Did he join the church because of Lori? Like, was he a non-member and then started dating her and joined the
Yes.
church?
He
Oh,
joined the
wow.
church for her. Yes, he did.
Wow.
But
Oh,
he was tithe paying because Krisha has receipts, and also we know that he had his undergarments from going to the temple because Kay had accidentally seen him in him before. So we know that he was a good Mormon man, and he intended to be a good Mormon man, even no matter whether
yeah.
she was with him or not.
Yeah. You have to go through your endowments to get garments, people. Like, you can't.
Exactly.
Yeah. Wow. And he did that for her. Oh, my. All right. Let's see. We got 2 more pages of this to go through. And we're still trying to figure out Chandler versus Gilbert. I'm still trying to figure out Chandler versus Gilbert. Like, where is what? Additionally, all extractions relating to the download of Charles Vallow's devices have been previously disclosed. So that was by Chandler. It looks like Chandler Police Department is the one that did the extractions, probably based on this, but I don't know for sure. On September 19th, 2024, the state filed the state's motion for defense to comply with Rule 15.4E. On October 15th, so about 4 weeks later, the court issued a minute entry denying the state's request. That's interesting. The state filed a request September of last year, so that was when Lori still had her public defense team, for the defense to comply with Rule 15.4E. And I think she just filed some stuff that had to do with Rule 15.1, 2, 3, 4, 5, 6, 7, like multiple Rule 15 point whatevers. Pretty sure she just filed a whole bunch of that stuff, and the state objected to some of it. But on October 15th, 2024, here we are, last sentence on this page, the court issued a minute entry denying the state's request. Wow. The state is unaware of any other public records requests to either Chandler Police Department or Gilbert Police Department. Here we are with both of those small, like, suburbs of Phoenix, East Valley, by the defendant on her defense team. On February 6th, 2025, the state disclosed. Okay, so we just saw Lori file objections to the Maricopa County Sheriff's Office sharing some of her texts or calls with her Idaho appeal attorney. I wonder if this has to do with this. On February 6, 2025, the state disclosed Maricopa County Sheriff's Office jail calls made by defendant Lori Vallow Daybell between October of 2024 and January of 2025, as well as jail messages and photos from defendant Lori Vallow Daybell's tablet for the time period of October 24th, 2024 to January 24th, 2025. So that's October, November, December, 3 months. 3 months of jail messages, photos. On March 18th, 2025, the defendant filed a motion to dismiss for violation of attorney-client privilege communications. The state is currently working on a response to this motion. Why don't we have a response to this motion, state? Why don't we have an easy answer as to why you're intercepting her text messages? The text messages of a defendant in a high-profile case. Why don't we have an answer to that? If you screw this up, state of Arizona, like the state of Idaho screwed it up, that's on you. That's 100% on you. Just don't violate her rights. And if you did, I'm going to be beside myself. The state is currently working on a response to this motion. The state hereby incorporates its response to defendant's motion to dismiss for violation of attorney-client privilege communications as a part of this response. What? We're working on a response, but we're incorporating a response? That doesn't make sense to me. Anyway, all right. Paragraph 3.
I'm confused.
I am. I'm really confused.
Well,
I'm really confused.
this is
I'm
what
just,
I'm confused about is if you're in the dang jail or the prison, they listen to all your phone calls and read all your mail. The fact that she's
well,
her own lawyer, does that make it different?
well, they do, but they do not have the right to listen and record privileged communications between you and your attorney. And that's what she alleged in that filing, in that motion.
Oh, okay. Of
That
course.
that it was with her, specifically with her Idaho appeal attorney, and she mentioned it by name. I don't need to do that, but she said I had privileged communications with my Idaho appeal attorney, and they intercepted them and shared them with the state of Arizona. So I do have a problem with that. Like I think this is an evil woman, and she did evil things. But I will fight for a defendant's rights, like, because justice doesn't happen if you violate a defendant's rights.
Krisha says that it reminds her of Diddy accusing the feds of doing something similarly, allegedly.
That's a good point. Yeah, that's a good point. And yeah, we don't need to get into Diddy. Diddy's a whole nother Diddy's a whole nother thing. But
go ahead.
I mean, it's not that hard to preserve a defendant's rights, constitutional rights. Let the justice system play out and let justice for the victims happen. Like Richard Allen in Delphi is how my channel got started. I am from Lafayette, Indiana, which is 20 minutes south of Delphi, which is where those 2 unalivings of those sweet teenage girls happened. And the police investigation and the prosecutorial misconduct and the judicial from the judge, from Fran Gull, was just ridiculous. So I don't know to this day if Richard Allen is guilty. The jury found him guilty. So right now he's going to spend the next 130 years behind bars. Obviously not. But I mean, because all you got to do is follow the rules of investigation, follow the rules of evidence collection. Karen Reed, what are you doing what are the Canton Police Department officers doing picking up frozen blood in red Solo cups and putting them in brown paper bags from the grab and go? Like, seriously, just follow the rules of investigation, follow the rules of prosecution, observe defendants' constitutional rights, and justice should be served 99.99999% of the time. Yeah, I'm confused by what the state's saying here. I'm confused.
You know, in Memphis, can you hear me?
Yeah, I hear you.
There's a murder of a lady in one of the, like, it's not a park, but it's where there used to be, like, I think a railroad tracks, and they took it down and they made like a bicycle or a walking trail. Anyway, this lady got killed, and they were after the murderer, and they chased him across 2 counties, and they got him. And when they got him out of the car, there was people videotaping it. They got him out of the car and proceeded to beat the crap out of him. So
Oh
then,
my God.
instead of talking about, oh, he's a bad murderer, now this guy has got a case against the police for brutality. And I'm sure, I'm not against, I know murder needs a good whooping, but it's not the police's job to do it. And it gets in the way of having a good, clean, you know, a good, clean prosecution of these people. That's why it's so important that everybody do their job and do just their job and do the best job they can do on each part of it. The police, the investigators, the people who work down there, all of them have to do their part and do the best they can.
Yeah, we have a justice system, and it's not perfect, but it is one of the best justice systems in the world. So let it work its course, and maybe 1 out of 10,000 times an innocent man will get convicted. Maybe 1 out of 10,000 times a guilty man will get released. But overall, we have a good justice system if you let it play out. You got to let it play out. And we need to here. So we saw it play out in Idaho. And okay, here we go. We got to dive back into that now if I'm going to talk about Idaho, because the state did not follow the rules of discovery. She's not on death row in Idaho like Chud is. The death penalty got taken off the table for Lori in Idaho because the state did not follow the rules of discovery. That was their punishment. You cannot sentence her to death. And even though she was found guilty on all 3 counts, she can only serve 3 life sentences, 3 consecutive life sentences in Idaho for Tammy and JJ and Tylee. And that's the state's fault. And I will equally blame the state of Arizona if they screw this up. I don't understand why you can say, so I'm looking at the second line down on this filing. The state is currently working on a response to her motion for violation of attorney-client privilege. The state hereby incorporates its response to defendant's motion to dismiss. How are you working on a response and you incorporate a response? That makes no sense. Anyway, all right, paragraph 3 on March 6, 2025, the defendant filed a supplemental 15.2 notice as to both CR 2021 and CR 2022. So that's Charles' case and that's Brandon's case. 2021 is Charles, 2022 is Brandon. The state requested that separate notices be filed for each case number so the state would know which defenses and witnesses applied to each case. On March 7, 2025, the state learned that defense noticed witnesses Nate Eaton. The defense noticed witnesses. Nate Eaton is a reporter from Idaho. I saw him. Trace and I saw him. I think we just saw him on the 11th, though. I don't think we saw him on the 18th. He wasn't there the 18th, but he was there the 11th, which is after this date, March 7th. The state learned that defense noticed witnesses. He said he hadn't been served. As of March 11th, 2025, Nate Eaton had not been served with any type of subpoena or notice to appear or anything like that. I will guarantee you that. And he also said he was going to bring me a t-shirt next time he saw me. So I will also notice you of that. He owes me a t-shirt. Anyway, March 12th, 2025. So this is the day after the March 11th hearing. Defendant filed a supplemental 15.2 notice for CR 2021. That's Charles' case, the one she's currently going to trial for, and a separate 15 notice for 2022. Ooh, I don't know that I've seen those. I need to get back on the docket and see which one is which. On March 16th, the state filed a motion to preclude all witness noticed on the defendant's supplemental. At the final trial management conference on March 18th, So that was the hearing a week ago tomorrow morning. The court heard from the parties on the motion. She claims that she wasn't a participant in that final trial management conference. Remember that document we saw like about half an hour ago, 45 minutes ago? She claims she was not a participant in that hearing. The state advised that it did not have contact information for most of the parties. The state also advised that one of the defense witnesses, Nate Eaton, was a reporter. Reporters can be witnesses in trials. I'm not saying I want to be one ever. I'm just saying they can be. Nate Eaton contacted this prosecutor. Oh, wow. Nate contacted the actual prosecutor after court on March 18th, and this prosecutor called Mr. Eaton back. Mr. Eaton advised this prosecutor that his knowledge about this case comes from his interviews and investigation as a reporter. Fair enough. Mr. Eaton also advised that he had not been served with a subpoena, just told you that, by the defendant, and he hoped to be in court for this trial. Trace, am I gonna tell what I said to Nate when he walked in on this channel, on Chris's channel? I'm gonna tell everybody that the first thing I said to Nate when he walked in. So Trace and I got in there first, and then Nate and Justin walk in, and I looked up to Nate and I said, "Are you sure you should be here as a potential witness for the defense?" I said that to Nate Eaton. But he's like, "I have not been served." Nate said, "I have not been served." And in this document, he is again reaffirming that he has not been served with a subpoena. This prosecutor advised Mr. Eaton that even if he was not served, he still could not be in the courtroom if he was a noticed witness. Holy cow. Okay, that goes to what I just said. Oh my gosh. Look at this, people. Look at this, people. The prosecutor advised Mr. Eaton that even if he was not served, he still could not be in the courtroom if he was a noticed witness, and the rule of exclusion was in place. Maybe that's why we didn't see him, Trace, on the 18th. Right? We just saw him on the 11th, right? Refresh my memory. I think we only saw him and Justin on the 11th and didn't see either of them on the 18th. And then Justin was doing like his podcast thing after the trial. Wow. This prosecutor advised Mr. Eaton that this prosecutor would try to interview the witnesses and file a motion to preclude those that should be precluded at the end of next week. So that's this week, guys. Nate Eaton is going to have some type of an interview this week, and then the prosecutor is going to tell him if he can or cannot be at trial. Wow. Wow. La Mesa, I love it. I love it. La Mesa, I'm not gonna lie, I'm a fan of Nate, and I know that that's not a popular opinion with everybody, but I dig him. Like tracking down Lori and Chad to Hawaii was just like one of the greatest reporter moves ever. One of the greatest investigative reporter moves ever. All right, sis, what up? Are you still out there? Did you fall asleep on me?
No. Did you know that I fell asleep last night just before Crusher went out? She must have
No.
I don't know. I don't know what happened. I was sitting there, and the next thing I know, it was over with, and I was like, "Oh crap!" So, but no, I'm not asleep. Well,
I think that's all the docs. I think that's all the doc drops.
Someone, Mohawk Mom, said that Pryor, that was Chad's lawyer, also had served Nate too, but the news channels had it stopped. So the news channel lawyers had it stopped. So I don't remember that happening, but it could, I mean, I sort of kind of do, but I don't. I have heard, I don't know how anybody follows all the true crime. I really don't, because my brain has been stretched with this one and all the
Yeah.
other Mormon related crimes that we've learned about, that I can't,
Yeah.
sometimes I get my monsters mixed up sometimes.
It's easy to. It's easy to. And I think that's one of the things that the series that Kresha and I have been doing on Tuesday nights with the Glenn Pace memo and the Mormon BS. I think that's one of the main things we learn is that the LDS Church tries to appear very mainstream, and they have distanced themselves from this, but it took them a freaking long time to distance themselves from this and excommunicate Chad. I mean, it really did. Like, it lends itself to offshoot cults. It does. Yeah. And there's no other way around it. So you just got to be educated, and we got to help educate our fellow human beings, right? Exactly. And lift each other up.
Kresha, were you going to come up and show anything? Did you want to? You don't have to. I'm just, if you were wanting to, I didn't want to end it and not have asked you, did you want to?
Kresha, yeah, we're doing it tomorrow night. We're going to end the Glenn. Okay. We're going to end the Glenn Pace memo tomorrow night, Kresha. Yep.
Okie dokie. All right then. So I tell you what, I want everybody to be sure and like this video, and also when we're done, if you could go and put some comments.
Wait, Kresha's here. Kresha.
Oh, well,
hey there.
That too. But I do want y'all to put comments on the videos, because the algorithm is like, if you put like a sentence or two, it helps to do the algorithm.
Hold on.
Yes, ma'am.
I don't have my volume up or something. But
we can hear you.
Mic. Hold on.
We can hear you.
Hold on. I got to clog up the show. Hold on. Let's see right here. There we go. Now. Okay. Can y'all hear me? And can.
Yes.
You're on.
Yep. Okay. I was waiting on something. Anyways, I'm sorry. It was going through my microphone. It does that from time to time. Anyways, y'all did a great job. Thank you so much. It really sucks not having my phone, but
I get it. I get it.
What it is.
I need a new phone. Like, I seriously need a new phone.
Well, Trace and
mine is a new phone.
That's what I say. Trace and Beach Bum called me up and they were like, "We've got the scoop here. Joe's got the scoop. We need to get on. We need to break it. I was like, wake up, Donna, wake up." So, Kresha, you might want to go back through the thing, because I didn't do any settings. I don't know.
That's what I was working on. Yeah, I went and added his channel and, just more what the video was about today, the live stream. So, no, you did good. Much. I mean, that's all we can do, right? This hooker is always breaking. She's breaking my time for sure.
You crack me up every time you call her a hooker.
Well, she's a hooker, Joe. I mean, shit. She's a hooker.
She really is.
There's no better word, man. It fits her. Hooker, hookerella. I mean, she's a hooker. She's a concubine. All these people were worth killing to her. So she's a hooker. She earned that title a long time ago. Anyways, it makes a few people laugh, and I like that it does. So, anyways, but so what did y'all glean from this? What is the couple things or things that stand out the most?
Like I think sometimes I just think she just files shit to file shit, like to put records, because it's a combination between her handwritten motions and the typed motions from her paralegal. So it's like she's just like throwing as much stuff against the wall she can to see what sticks.
Oh yeah. Well,
I think she don't want your mama in the courtroom. And
I don't blame her.
Krisha, it seems so strange that somebody in the chat last night kept asking, was it true that your mother wasn't going to be in the courtroom, that she would only
Treva. Yeah.
Yes. Do you know something we didn't know, Treva?
I don't know where that came from though, because I hadn't heard that. And mom was in the chat at the time. Well, I think it was mom under Larry's name or whatever profile. And I was like, okay, I mean, I'd like to know too if she's going to be appearing as a witness on Zoom, or if Lori's going to get granted this motion and not have her at all.
She don't want to see those eyes again, is what it is.
I don't blame her. I don't. That's my mom. Trust me, I've had them eyes. You don't want them. But I've never killed people. So, I mean, I can imagine. Because, like, as soon as we found out that Lori was going to be doing this, being her own attorney, then, I mean, I asked mom, personally. I was just, and she said, oh my God, I cannot wait. And that threw me. It threw me off because, like, I was so offended by it. Just the fact of how Lori was even going about this. Like, oh my God, she's a terrorist, like it pisses me off. But then my mom, her response was, again, it knocked me off because I don't know. I didn't know she was like, bring it, basically. So anyways, was that too long? I'm sorry. I get a little crazy.
I'm muting my thing here because Brutus is snoring really loud over there.
No, sure. Little brute.
I do that when I start snoring. I'll mute myself out.
Donna, but I put her to sleep every time.
Oh my gosh. Last night, I don't know. My mother told me today, she said, I believe you have long COVID because I fall asleep all the time. I used to never do that. I don't know what's the matter with me.
Oh, girl, you're getting up there, like as we get older, we can start doing more and more weird things.
That is weird now.
I mean, I know, right? But you're not alone, so never feel that way. Okay? Oh man, embrace it. Embrace it.
All right, y'all. So tomorrow night we're gonna all go over and we're gonna have Krisha and Joe. We're gonna do a collaboration on Tuesday night, and we're all gonna be there for it. And so I'm gonna do so. We're doing this as justice for Charles and JJ and Tylee and Tammy. And who else am I missing?
And Joe.
And Joe.
I don't know. I always say justice for Tylee, Charles, Tammy, JJ, and Joe. I don't know. It's just like how it rolls off.
And I'm telling you, and justice for them. And thank goodness it's not more of them, and it would have been.
It would have been, my mom was on their hit list, so I would love for my mom to be able to confront Lori. I want to confront her. Oh my God, I want to confront her. It's probably best I don't, though.
No, but you got the same eyes. You got the power in them eyes like your mama. So just remember that.
But yeah, thank y'all so much for doing this. I really appreciate it.
Thanks for having me up. Thanks for having me up.
I figured I was making my computer. Yeah. See you tomorrow night, Joe.
All right. Good night, everybody.
See ya. Good night.
So long, farewell.
I'll beat a zing.